Good afternoon, Honorable Justice, respected dignitaries, esteemed speakers, distinguished advocates, faculty members, research scholars, participants joining us from different places. On behalf of the Department of Studies in Law, University of Mysore, it gives me immense pleasure to welcome you to this international webinar on smart courts, pioneering the digital pathways to justice in India. We are honored to have with us distinguished and well-respected Judge, Honorable Justice Suraj Govindaraj, as a chief guest of today's program. And in the same line, we are honored to have Shri Uday Ola, Senior Advocate and former Advocate General of Karnataka, and as a guest of honor, and other distinguished and well-known senior advocates, High Court of Karnataka. I, Syed Qudrat Hashimi, Organizing Secretary of today's program, have the
Can you hear me?
of convening today's session. Before we begin, I warmly welcome the President of today's program, Professor Dr. M.S. Benjamin, Dean Faculty of Law, Chairman, Department of Studies in Law, and University of Mysore. I now humbly request our respected President of the program, Professor M.S. Benjamin, to address the welcome address to the gathering. Sir, over to you.
Yeah, judges come. Yes, judges come.
Good afternoon to one and all. The distinguished guest, Honorable Justice Suraj Govindaraj sir, Senior Advocate Sri Uday Ola sir, respected speakers, Sri B.C. Thiruvengadam, Sri P.P. Hegde, Sri V. Raguraman, invited delegates, esteemed faculty members, practitioners, research scholars, students, participants, and ladies and gentlemen. A very warm welcome to each one of you to this international webinar on Small Court Pioneering Digital Pathways to Justice in India, organized by the Department of Law, University of Mysore, Mysore, Karnataka. In the late 1990s, the idea of a smart court was introduced by the Chinese government to recommend laws and draft legal documents. Judges will be consulting with artificial intelligence before delivering the final verdict. The smart court is connected to the desk of every working judge across the country. According to China's Supreme People's Court in Beijing, the smart court system has made a significant contribution to the judicial advancement of human civilization. Smart court represents a shift toward greater transparency, efficiency, inclusivity, and accountability. The smart court system promotes easier access to justice, enables quick dispute settlement, saves cost and time by moving judicial process online, and ensures that judgment can be enforced without legal hurdles. In terms of the judicial system, use of digital technology and artificial intelligence promotes transparency, openness of the system, strengthen public trust in judiciary. Therefore, almost all countries, US, UK, Australia, Canada, and India have embraced new technology through the adoption of smart courts, that is, integrating technology with judicial system. However, there are concerns or issues relating to use of some technologies, judicial independence, issues linked to privacy and data protection, quality of internet service, malfunction problem during the online hearing process, and willingness of parties to participate on online hearing process. It also raises a serious question on the reliability of data fed to artificial intelligence with technology. With this backdrop on the topic, on behalf of the Department of Law, University of Mysore, Mysore, Karnataka, I extend a very warm welcome to our chief guest of the program, Honorable Justice Suraj Govindaraj sir, Judge, High Court of Karnataka, Bengaluru, to our guest of honor, Sri Udayawalla Sir, Senior Advocate, High Court of Karnataka, former Advocate General of Karnataka, Bengaluru. I also heartily welcome keynote speaker Sri B.C. Tiruvengada, Senior Advocate, High Court of Karnataka, International Arbitrator and Mediator, Bengaluru, and distinguished speakers Sri P.P. Hegde, Senior Advocate, High Court of Karnataka and Supreme Court of India, Sri V. Raghuraman, Senior Advocate, High Court of Karnataka, Bengaluru. I also extend a heartfelt welcome to each and every participant, members of the organizing committee, coordinators, Sri Syed Asmi Kudrat, Sri M.K. Srinivas, and Sarah Benjamin. Once again, welcome you and thank you for being part of this important webinar. Thank you.
Thank you. Thank you so much, sir, for your enlightening words. I now take the privilege of inviting our respected chief guest to kindly deliver the inaugural address and share his lordship perspectives. Before we proceed with his lordship, I request Ms. Sarah Benjamin to introduce sir, then we proceed. Sarah, over to you.
Good afternoon to everyone present here, esteemed dignitaries, respected colleagues, and dear participants. It is my proud privilege to introduce our chief guest, Honorable Justice Suraj Govindaraj, Judge of the High Court of Karnataka, Bengaluru. Justice Govindaraj was born on 14th May 1973 and is an alumnus of the prestigious National Law School of India University, Bangalore. He enrolled as an advocate in 1995 and went on to build a distinguished practice of over 24 years in civil and commercial laws, appearing before the Honorable Supreme Court of India, various high courts, and national tribunals across the country. He was appointed as an additional judge of the High Court of Karnataka in September 2019 and was elevated as a permanent judge in March 2021. As a forward-looking jurist, Justice Govindaraj has been at the forefront of judicial reforms through technology and innovation. He is a member of several significant committees constituted by the Honorable Chief Justice of India, including the Phase 3 Advisory and Monetary Committee of the E-Committee, the Neutral Citation Committee for Standardizing Judgment Citations, and the AI-Assisted Translation Committee, which seeks to make court judgments accessible in regional languages across India. At the Karnataka High Court, Justice Govindaraj has been instrumental in implementing digital innovations such as the launch of the High Court Telegram channel with over 45,000 members, revamping the official court website, integrating postal systems into judicial workflows, and streamlining advocate registration with real-time dashboards benefiting more than 13,000 advocates and 2,500 government departments. He has also pioneered virtual mediation platforms and played a key role in drafting amendments to the Civil Procedure Code. In addition, he serves as the governor of the Karnataka Mediation Center, a member of the Computer Committee of the High Court, and an active contributor to rules and judicial reform committees. His vision has consistently been to blend efficiency, accessibility, and innovation with justice delivery. Justice Govindaraj is a sought-after speaker at the National Judicial Academy Bhopal, regional judicial conferences, and reputed law schools across the country, where he shares his insights on judicial reform, procedural efficiency, and digital transformation in the judicial system. Today, we are truly honored to welcome a jurist who embodies legal excellence, institutional leadership, and a forward-looking vision for the Indian judiciary. Please join me in extending a warm and respectful welcome to our chief guest, Honorable Justice Suraj Govindaraj, sir. Thank you.
Your Lordship, the floor is yours. Yes, you may. Yes, Your Lordship.
No, I'm. Firstly, apologies for being delayed. There was some confusion. That confusion was entirely on my part, and the mistake is on my part. It's great being here. Mr. Udarla, senior advocate and former advocate general, my former senior. Mr. Thiruvengadam, Mr. P.P. Egede, Mr. Raghu Raman, Mr. Srinivas Murthy, Mr. Srinivas, and Mr. Benjamin. The topic that you have chosen today as smart courts is something which is very dear to me. Apart from being dear to me, it's also a very relevant topic in as much as that is the way to go and that is the future. You are fortunate to have Mr. Holla here, who was probably one of the first lawyers in Bangalore, at least in Bangalore, if not across the country, who had computerization at his office before anybody else. No other lawyer had computers in Bangalore except for Mr. Holla, with nice setup with printers. There was a room for computers. There were people who were working on it. And while lawyers were using typewriters, and some of them were using even handwriting, Mr. Holla was at the forefront at that time with computerized printouts. We had dot matrix printers at that time, 9-pin and then 24-pin, etc. Those were all the bygone eras of 1990s, or if you start thinking of what it was in 90s and what it is today, it is completely different. And today we are speaking of smart court. When many of the people today also, unfortunately, that is one of the topics that was mentioned as regards the digital divide, which I'll also come to in a short while, is how do we make it into smart court into a reality? What is a smart court? Smart court, normally when you say, defining the smart court would also be required. Smart court paradigm is completely different. A smart court is not a futuristic dystopian vision of a courtroom presided over by a robo judge, as some people would think. Normally, whenever you say smart court, it is like a robo judge sitting there. The robo judge is going to decide the matter. It is not so. It's not such like a dystopian saying. It is not independent of human intervention. Instead, it is a sophisticated judicial system that strategically integrates digital technology and software to enhance the efficiency, accessibility, and transparency of legal processes. These are the key terms, the efficiency, accessibility, and transparency. Today, we have more than 5 crore cases which are pending. How do we bring about efficiency? How do we bring about accessibility to people? Though there are 5 crore cases pending, is it accessible to everybody? On the one hand, we say it's a docket explosion, but also we say it is docket exclusion. Are everybody included? There are a lot of people who are not included in this. So efficiency, accessibility, and transparency being the key, could smart courts bring about that? The fundamental philosophy would be that technology should augment rather than automate the judiciary. This would involve principles of human in the loop. What we call it as a human in the loop. A human is always to be in the loop in the entire process, whether it is filing and scrutiny, whether it is arguments, whether it is research, finalization of the research and finalizing judgment. Is always a human in the loop, where a human judge remains the final adjudicator, with technology serving as a decision support tool. So we need to make that first aspect of it as a layman. When a person speaks of smart court, when I speak to a lot of people, they say it's artificial intelligence, it is robo judges, it will happen, efficiency will come about, it will be like a assembly line of manufacturing of cars or the like, that something will be put across and finally the judgment will come out as it is, and like the assembly line happens and car can be manufactured in 2 minutes, but judgment will come in probably instead of 2 minutes, 3 minutes. That is how it will happen, is what people think. That is not what can be. Smart court is this use of technology. It may be hardware, it may be software, but finally it is the human in the loop, which we need humanness, where we need compassion, where we need understanding of men and material by the particular judge and by the lawyers. If we go by that, then we won't even need lawyers. If a judge is not required as a robo judge, then there'll be a robo lawyer. There'll be a robo litigant. There'll be a robo officer. Everything would be that. So that is completely dystopian. So firstly, we need to get into our mind that as a smart court is not that kind of a dystopian system. The approach has to be critical, safeguard against phenomenon known as automation bias. Automation bias is well-documented psychological effect whereby decision makers place excessive or inappropriate trust in automated systems, potentially adjudicating their own, abdicating their own discretionary judgments. In as much as we can't depend on this is as regards artificial intelligence, we can't depend on artificial intelligence so much that we abdicate our discretionary judgment. The introduction of AI-powered system in judiciary would create a risk for judges to be over-reliant, but at the same time, there would be a requirement that we distance ourselves and we maintain the human in the loop concept. The foundational pillars of this smart code digital judiciary. We have a digital economy today. Today we have got UPI payment, we have got FASTag, we have everything is digital. If everybody were unmuted and if I were to ask a question as to when anybody has gone to the bank last, probably they would say not in probably 2-3 years. Today we don't need to go anywhere. Today we don't need to go to a bank. We can do an online transaction. MEFT, RTGS was the cutting edge of technology some time back. Now UPI is the cutting edge of technology. Using the phone, I can transfer it to any phone number, any mobile number, any bank account, or scanning a QR code, transfer it to that particular account. So the digital judiciary is what we need to look at. So far, the judiciary has not been made digital as such because judiciary needs that human intervention. But it is time that we have digital tools which would help the judicial system, not only as the judiciary. When we say the judiciary, it would be the judges, obviously, the lawyers, the court staff, the litigant. All these are being the stakeholders in this particular process. Everybody needs to be part of it and needs to get benefit of it. So access to justice, when we start, is without the litigant, there is no judiciary. It is all for the litigant that the judiciary and the system is. So if we take that as the base, then access to justice is the key in the digital judiciary. We have to provide a system where the digital divide which had been mentioned is not something which will come in the way of the access. One way of saying it is that the digital tools not being available, therefore the digital divide will prevent access. The other way of looking at it, by providing digital tools, can we provide better access to the judicial system? So it is two sides of the same coin. I would not say two sides of the same coin. It's two wheels of the same cycle or the chariot, that both of them have to go together. Because when we say two sides of the same coin, then each side doesn't see the other. So there is never a meeting point. So what we need is a meeting point on this digital divide concept, where digital technology could bring about a bridge between all the haves and the have-nots, so that even the have-nots are able to access the judicial system. This we are seeking to do by introduction of e-Seva Kendras. In Karnataka, we have got 75 e-Seva Kendras. In terms of the phase 3 of the e-courts project, 7,200 crores have been designated, out of which large amount of money is also designated for e-Seva Kendras. So we'll have e-Seva Kendras at each court complex, where any person can visit the e-Seva Kendra complex, get the details of his or her case, get to know about what is to be filed, even enable e-filing at the e-Seva Kendra. The lawyers who do not have computers, etc., could also use the e-Seva Kendras for the purpose of filing as also online hearing. This would bring about also the issue about cyber security and data integrity. We are looking at how the sensitive data of all the litigants, etc., are protected in terms of the protection of the data in the database. We'll have to do capacity building and digital literacy, capacity building of both the staff, the lawyers. The training has to be given even to the judges, so that the limitations that any person may have can be avoided and the system could be put to best use. Now, behind all these things, what we would require is evolving legislations and a regulatory framework. Our rules, which are there as regards the civil rules of practice or the High Court rules of practice or CPC, were drafted some time ago where there was no digital requirement. Even today, we have got BATA, we have got one of the rules saying that dole has to be beaten, drums have to be beaten. Those kind of things still persist in our rules. One of the rules I also remember is until the port, until the steamship, some particular amount, until the railroad station, there is some amount. Today, we are in the digital era where we have email, the communication, the service of summons, both in civil proceedings and criminal proceedings could be by emails. So these aspects, I'm just giving an overview. There other people, better people would be speaking on it. The legislation and regulatory framework would be required to be looked into. It would be required for universities like the University of Mysore to probably set up a center to look at what rules could be changed, what law ought to be, what law can be, and how it can affect the outcome of the judicial process. Insofar as technology is concerned, there is no limit to technology. As far as all the commercial companies are concerned, they use the best of the technology to achieve what they want to achieve. Artificial intelligence and machine learning is not something which is new. It is being used for a long time. Robotics is not something new. It is being used for a long time in manufacturing. We'll have to start using artificial intelligence and machine learning in our domain, that is the judiciary domain, which would include all the stakeholders, as I said. When I say judiciary, it would include the judges, the lawyers, the litigant, the court staff, and even the academicians, everybody who is associated with it. Because ultimately, it is why is the judiciary there? It is to give succor to a person who is being wronged or who has a grievance. He'll approach the court to get relief for his grievance. So when he approaches the court for grievance, and if his grievance is settled in a proper way, that has an impact on the society. So everybody would be a stakeholder in this. If proper judgments are given and it's handled in as short a time as possible, then the value proposition is that the society benefits. If the society benefits, all of us benefit. So the application and value proposition is as regards the proper implementation of a grievance redressal system in the form of a judicial system. In this particular aspect, the use of artificial intelligence and machine learning would give rise to a lot of ethical dilemmas. How far do we use artificial intelligence? It is always very easy for any of us to think that this artificial intelligence is doing my job. Let it do. This artificial intelligence is drafting this pleading for me. Let it do it and give it to me. I'll just use it. This artificial intelligence is drafting my written submissions and giving it to me. After doing a research, let me use that as what it comes. But as all of you know, there have been cases where artificial intelligence has led to hallucinations, where case laws which do not exist have been pleaded. The facts which do not exist in that particular case have been pleaded. The law which does not exist has been pleaded. In one of the cases, the lawyer has been imposed a fine of $50,000 or something like that. In one other case, a litigant created an avatar of a younger avatar of himself to come and argue the matter before the court. Instead of using a lawyer and instead of himself arguing, all the facts were fed into the system, and the avatar was created using artificial intelligence, by which the avatar it looks like a person, but of course you can make out that it is automated system. When it speaks, it can't be as simple and as easy flowing as a human being speaking. That is how the judge came to know that what is this, who is this. Then when the inquiry was made, it was seen that it is artificial intelligence avatar. So these kind of things happen as to, it is, as a human being, we will try to reduce our work as much as possible. And if something else is able to do our work, we will tend to let that do. But that is not the ethical and moral way of doing it. That is a line that we need to draw somewhere and say, what is it that AI can be used for? What is it that machine learning can be used for? And this far and no further. Of course, this again, firstly would require a self-imposed restriction. Secondly, it would require a legislation to come about in the form of the rules and regulations. The Kerala High Court has come up with a policy as regards the use of AI by judges. If you could look it up on the Kerala High Court web page, it's a pretty comprehensive policy. Of course, it is an evolutionary policy. It will keep on evolving. But to start with, Kerala has led the way again, and there is a policy on that. Insofar as what you have seen as virtual hearing and online dispute resolution is going to be the future. It may not be required for people to travel. We don't require large courthouses, which will benefit in terms of the cost of implementation, cost of infrastructure. We are always short of funds. So if we don't need large courthalls, large buildings, then it would bring down the cost of capital cost as also the revenue cost. COVID-19 has acted as a global accelerator in this. Mr. Olla, Mr. Trivandrum would probably be able to speak on how it has affected and how it has helped them after COVID-19 and attending to matters. Many a time they can sit in the office and attend different courts in different parts of the country. Forget in Bangalore, they can be attending different courts, they can represent different clients. Therefore, the client has also got accessibility through a lawyer, not accessibility only to the court, but accessibility to the right lawyer to appear before that particular court is also a part of accessibility. So that seems Mr. Olla or Mr. Trivandrum cannot be there in 20 different places at the same time, because there's a Newton's law is there of traveling. Two things cannot occupy the same place at the same time. One thing cannot be at the same place at the same time. Two different places at the same time. If a litigation is there in Bangalore and another litigation in Bombay, earlier what would happen is a person would have to travel to Bombay and then attend. Now a person sitting in Bangalore can attend in Bangalore, pass over in the Bombay matter and appear in the Bombay matter. So the accessibility of litigant through the right advocate is also part of this accessibility concept. And one of the way of doing it is through virtual hearings. And today, virtual hearings, like how we are doing today as a webinar. Earlier, we could not imagine doing this. It would have been the University of Mysore having a conference in the auditorium of the University of Mysore, where whoever could attend physically, get the knowledge of it. Today, this webinar, anybody can see it across the world. And once it is recorded and put up on YouTube, it can be seen and re-seen many a time. That is the power of virtual hearing. That's the power of recording and online. Now, this is going to be, this has already been extrapolated towards online dispute resolution. When I speak of online dispute resolution, I don't only speak of the court proceedings, I also speak of arbitration and mediation. So arbitrations could be conducted in an online manner. Mediation could be conducted in an online manner. The restriction of time and space will no longer be available. Right now, it is restricted. In future, it may not be. With even better technology of internet and the equipment that would be available. We could have holograms, we could have virtual presence, which is there that Cisco and other companies have been promoting, which could be used. The smart courts, there was a mention made of the Chinese model. In order of political correctness, I would not want to get into the Chinese model part of it. But on the technology part of it, it is absolutely brilliant. The amount of money that they have spent on the technological model and how it is being made use of is fantastic, in as much as the study which has been conducted indicates that any litigation is decided within 40 days. Now that is a dream for judges, dream for lawyers, dream for litigants. When we will be able to achieve it in our country, we'll have to strive towards it and try to make it into a reality. But in China, in 40 days, the matter is heard and decided by non-human judges. That's the problem. When non-human judges come about, the thought process, the humanness of it goes out. In most of the matters that come up before the courts, if 2 plus 2 is never equal to 4, 2 plus 2 can be 5, 2 plus 2 can be 3, 2 plus 2 sometimes can be 10 on the circumstances. In say, for example, in MVC matters, when we say disability report will come as 20%. But that 20% is on account of a leg being cut off, they amputated below the knee. Or even if it is not below the knee, even the amputation is below the ankle. Imagine if that person whose leg is cut off is a driver. That 20% or 10% which is shown in statistical purposes is actually for that person 100%, because he is never going to be able to drive. He is never going to be able to discharge his vocation where he was employed. And he has no other vocation because he is not trained for any other vocation. So how do you take care of that? So that is why this is one of the examples that I can give. I can give plenty of examples, but lack of time I won't. So it is never on the basis of statistics. Again, I would reiterate, 2 plus 2 is never equal to, is not always equal to 4. It could be equal to 10. Is disability of 10% could be a functional disability of 100%. Would the machine be able to understand that and decide on it? Unless there is a human in the loop, it will be very difficult to do that. One of the topics which have been mentioned is as regards the smart code projects in other countries. I'll just give you an overview of it. One of the countries is Brazil. Brazil, which has a lower population than us, has a higher litigation index. They have nearly around 8 to 9 crore cases which have been pending. They have implemented Justice 4.0, which is for managing judicial data. They have introduced Justice Boat. As you know, Brazil is having the Amazon running in between. So they have got a digital justice boat. There's a boat which is made into a court with digital access. AI and ML concepts in terms of categorizing the cases and placing it before the judge, that all of them, similar categories could be decided faster. Kenya, is an African country, but data analytics. Data today is king. And how you analyze data we keep on analyzing every day. It's basically data which is the information or the facts which give rise to a decision-making process. Kenya has implemented a robust analytical judicial litigation analytical tool by which the case duration has been brought down to 22%, and adjournments have also been brought down by 20% by creating rules on the basis of the analysis of the data which has been available. Singapore has introduced the e-litigation system, which is the integrated. But of course, Singapore spends 1.5% of GDP for its judicial technology. So 1.5% of GDP being spent is a large amount of money. We have 7,200 crores, but it is nowhere even equivalent to 0.1%. What we also have, as an aside, what I would also have to bring here is the delay in court proceeding, the delay in adjudication also has an impact on the GDP. One of the studies says the impact on the GDP. So if we are to spend more on technology, if the governments were to spend more on technology, judiciary doesn't have any money, If the government spends more on technology, there is a possibility of the judiciary being more efficient. European Union is another example where e-codex system has been implemented. Tanzania has done a fantastic job. Canada has introduced e-tribunal services. US had introduced Compass. Compass got into a problem because of the racial discrimination on AI. But these are things which are happening, which we could look at and see what we can do with them and better the system. It's a trial and error to some extent, and it's an evolutionary process to a large extent. It will evolve over a period of time. All of us need to put our heads together and see how to make the system better. If we do that, it will always be, it will always lead to a transformative grievance redressal system, as I said. Human element in legal practice and advocacy, I have already mentioned. What I would like to mention here, since it is a webinar organized by University of Mysore, is that the universities and colleges need to look at how to provide the new skills for the digital age lawyer. We are speaking of smart courts, we are speaking of smart judiciary, we are speaking of smart judicial system. But are the students coming out of the colleges ready for it? There are two reasons for this. One, the student has to be ready so that he or she can adapt to it as soon as she gets out of the college. Two, there may be older lawyers with whom they start working, who these students can guide in adopting and adapting to this particular smart court system. Therefore, bringing about a seamless integration between the old and the new. And that can be done if the university introduces one or two courses. Maybe it could be an optional course, or maybe it could be a compulsory course, as to how e-filing they could do, how could they apply for e-certified copies, how could they appear for in a virtual conference, how could they do a ODR, how do they need to dress up, what is the lighting which is required of there, how do they need to address the court in a virtual hearing. These are all life skills. These are all becoming life skills for a lawyer today. If a person is not able to join a virtual conference, he is forced to go from one court to the other because he does not know how to use virtual conference. If he is able to use it, he can probably sit and appear in 3-4 different courts. Otherwise, he will be restricted to one court, one matter, and his income is also going to be affected. So both in terms of representation and the financial ability of a student to appear before different courts, it will be required that this new skills for the digital age lawyer should be one of the curriculums which the university can propound and the colleges can implement, so the students are better equipped when they come out of the colleges. Of course, a lot of these things would depend on policy regulation. We need to look at the way forward. Right now, we need to look at a hybrid model. There cannot be one single model of only online or only offline. Maybe in another 20-25 years, it could be only online. We don't know. But today, we are in a hybrid system. The hybrid system is required to be implemented in terms of the applicable rules. Where rules are required to be changed, the rules are required to be changed and modified. The bridge of the digital divide would have to be made, and comparative experiences that I did speak of would have to be learned from and implemented. The foundations and framework of smart courts is a historic opportunity today in this day and age to reshape the delivery of justice. We have gone through, Mr. Alla has more than 50 years of experience in practice. He has seen from 1973 as to how this judicial system has progressed. Many of you have also similar experience. So when you have seen the evolution of the grievance redressal system as the dispute resolution, what we need to do, the vision is not a world where technology replaces human judgment, but one where it empowers it. The journey from traditional judiciary to a smart one would be complex, marked by both immense promise of efficiency and the profound challenge of equity and access in terms of the digital access that I spoke of. The measure of a smart court will not be its technological sophistication, but its ability to extend the reach of justice to all. To one and all, it needs to extend the reach, ensuring that the constitutional guarantee of fairness and equity remains a reality for every citizen. The future of justice, as I said, is a hybrid one, a system that is robustly digitized, but fundamentally human with a human loop. These are the basic structure of the smart court. On this basic structure, we need to build on and make it more robust and more inclusive. Then we'll probably be able to do implement a better and more accessible and more efficient judicial system. Before parting, I would only want to say this: between 1st January 2015 to 31st January 2023, if I were to ask you a question, can you unmute everybody, please? Can the host unmute everybody? If everybody is unmuted, this is a question for everybody. Between 1st January 2015 to 31st December 2023, can you guess how many cases were filed across the judiciary all over the country? Anybody has any guesses could just say that. Nobody?
About 2.5 crores.
Sorry?
About 2.5 crores.
2.5 crores. Okay. Any other guesses? Across the whole country, Mr. Ravindra.
Yeah.
Criminal, civil, all inclusive. Any other guesses? Okay, for lack of time and better utilization of time, let me answer that. We had 11 crore 77 lakh cases filed. That shows that 11 crore 77 lakh people who approach the court have the trust in the judicial system. Now, can you guess out of 11 crore 77 lakh cases, how many were disposed? Please unmute everybody.
Obviously 6.5 crores, because what is remaining is 5 crores, but then it adds up. 5 crores is after 23, there are more cases which have been filed. Therefore, more than 7 crores, 8 crore cases have been disposed of.
In my guesstimate, be about 11 crores.
Out of that particular period in that particular block, you are very close now. From 2.5 crore filing, you have jumped to 11.5 crore disposal. That is great to hear. 9 crore 97 lakh cases were disposed. Now, there is a fundamental flaw in this pendency. As much as the day it is filed, it is shown as pendency. Now, today, if a case is filed, it is shown as pending. It cannot be so. We need to have a system where we say that a case will take, the particular case will have a lifetime of so and so. It will have 2 years, 1 year, 3 years. It takes time. And that time, the reasonable period, if it is fixed, only after that time could it be said to be pending. Within that time, it is not a pending matter. That apart, what happens, as Mr. Ola rightly pointed out, is the question of filing. When we take this 10 crores into disposal, 11 crores into 11 crores 77 into filing, the filing which happens on day-to-day basis. For example, in the High Court of Karnataka, principal bench, our filing is around 450 to 500 a day. The 3 benches in Karnataka, the filing is around 800 cases a day. What is 800 cases being disposed on that particular day? Also, how many are being disposed? It's a constant, debit and credit balance which keep on happening. There's incoming, there's outgoing. And we have a case clearance ratio ranging between 85 to 95%. But it is that 5% to 10% which accumulates, which has resulted in this 5 crores. Though a lot of it is being said that disposal is not happening, The disposal which is not happening is 5 to 10%. 90% is getting disposed on time every day. The case clearance ratio, CCR, is around 90% every day in the district judiciary and the High Court across, more or less across the country. So it is this 10% which keeps on adding up. If efficiency is brought about through smart courts of 10%, we won't have this. Why I'm giving you the statistics is, if you look at it in a larger thing, it seems to be so much. But when you come down to the brass tack, it is only 10% difference in the what is being done and what more efficiency is required. If that 10 to 15% efficiency is brought about, there won't be any pendency. And if 20% is brought about, all the pending matters would get over in probably in couple of years. So that is where we need to look at technology to make it more efficient. Thank you. Thank you for inviting me. Thank you for having the patience to listen to me.
Thank you so much, Your Lordship, for your valuable insights and global perspectives. Now, I shall take the privilege to invite our guest of honor, Shri Mr. Uday Ola, Senior Advocate of High Court of Karnataka and former Advocate General of Government of Karnataka. I request my colleague, Ms. Sarah Benjamin, to introduce our guest of honor and we proceed.
It is my privilege to introduce our guest of honor, Shri Uday Holla, a distinguished senior advocate whose illustrious career spans 5 decades of service to the legal profession. Born on 11th January 1951, Shri Holla enrolled as an advocate in 1973 and quickly established himself as a formidable presence in the legal fraternity. With a profound knowledge of nearly all branches of Indian law, he has built a vast and diverse practice. Though based in Bengaluru, he has regularly appeared before the Supreme Court of India, several high courts across the country, and in both domestic and international arbitrations. Holla sir has also contributed to the local legal discourse by participating in international seminars and conferences in Hong Kong, the United States, and New Zealand, while authoring numerous papers and articles on corporate and allied laws. His contributions have been recognized with several awards for outstanding service and achievement. Beyond his professional accomplishments, Sir has always remained committed to public service. He has been associated with organizations dedicated to the welfare of the disabled, the elderly, and orphans. As the managing trustee of the Bengaluru Professionals Benevolent Fund, he has played a pivotal role in supporting advocates through medical assistance, death relief, and other forms of aid. A designated senior counsel, Sir has also served as the Advocate General of Karnataka on 4 occasions and is a past president of the Karnataka chapter of the International Commission of Jurists. His leadership, both within and outside the courtroom, reflects his deep dedication to justice, equity, and service. Today, we are privileged to have in our midst a legal stalwart, a humanitarian, and a mentor to a generation of lawyers. Please join me in extending a very warm welcome to our guest of honor, Uday Ola sir. Thank you.
Justice Suraj Govindraj, one of the most eminent judges that the High Court of Karnataka has, and who was born just a month prior to my having been enrolled as an advocate in June 1973. He's been in the forefront of computerization of the High Court, digitization of the High Court. In fact, I must bring this to the knowledge of every one of you. We were dependent upon, for our video conferencing, on a digital platform which was not Indian. He introduced an Indian-based digital platform. Initially, we were all very worried as to whether it can succeed. And today, it is one of the really good websites that Indian High Courts have. And thanks to him, today, we have one of the most excellent video conference facility in the country. It is said that every crisis throws up a challenge. When COVID-19 came into India, courts completely shut down. At that time, we had Justice Srinivas Oka, who was our Chief Justice. He introduced video conferencing and ensured that the courts functioned even during the lockdown. He introduced digital boxes. In fact, not only the High Court, even the subordinate courts, the trial courts started working. He ensured that there were separate rooms where the witnesses giving evidence. These were the introductions that came about because of that crisis. And today, everyone, even the oldest of people of my age or even elder to me, are online. And that is why I said every crisis brings about an opportunity. And that opportunity was resulted in a court system which was more accessible to the people. High Court of Karnataka has always been a pioneer in digitization. In fact, years back, in 2003, there was a case which was filed in Mysore. We have all heard or seen the multi-billion grosser, The Independence Day. There was this film which was produced by 20th Century Fox and Warner Brothers. Two witnesses, one of the persons in Mysore, he said this plot, this theme of The Independence Day is mine. I had authored a book and they've copied it and filed a suit for damages. Imagine if it had been given, Warner Brothers and 20th Century Fox would have had to file insolvency. What happened was, two witnesses on behalf of 20th Century Fox came all the way to give evidence in India. They came down to Bangalore, tried to travel to Mysore for the evidence. Unfortunately, there was this agitation. So there was a blockade and they couldn't proceed beyond Mandya. They had to go back and they went back to US. An application was filed saying that, look, there was a timeline by which the case had to be decided. These witnesses cannot come down to Mysore for evidence. Please permit them to be examined through video conference. In those years, 2003, video conference, examination of witnesses through video conference was all unheard of, at least in India. Resultant position was the trial court dismissed the application. Matter was filed in the High Court, revision petition, and in the case of 20th Century Fox versus the litigant who was the his name was NRI Film Production Associates Private Limited. High Court allowed examination of these witnesses through video conference. And imagine 2003, 22 years earlier, High Court of Karnataka permitted examination witness through video conference. That was the first judgment that was rendered in the country. Thereafter, 2 months later, Supreme Court in 2000, the case of State of Maharashtra versus Dr. Praful Desai, which is reported in 2003, 4 CC 601, permitted examination of a witness through video conference in a criminal matter. So this is the progress that has seen. Imagine the era when I came to the bar. We had typewriters, 1973. We would type a draft. Once we make the corrections, it had to be retyped. And any further corrections, it had to be re-retyped. Look at all the situation where so much of time was wasted, so much of paper was wasted. All that has changed because of the digitization, the technological advancement. It is in this era where, as Justice Suraj Govindra rightly said, youngsters would be able to help the elder people like me. Today, everybody is online. Everybody is, in fact, younger generation, as I always jokingly say, they are today born with iPad and iPhone. They literally come out of the womb, I think, with the iPad and iPhone. I remember my younger granddaughter, at the age of 2, snatching my iPhone and iPad and started operating it herself. This is the era. And therefore, this technology that is there should be evolved and should be integrated with the court system. And that is what Justice Suraj Govindra rightly said. And that is what we are seeing. But of course, there is always a danger of AI. What is it? Human compassion, human sympathies, human feelings, AI will not have. It can also have the bias of the person who has been instrumental in ensuring in production of that AI system. Therefore, as was rightly said, human intervention is absolutely essential. Without the human intervention, there cannot be a judicial system. That ultimately these are the tools which ensure speedier dispensation of justice. When you look at the Western world, you have 10 times more judges than in India. If you have 10 judges for a lakh of population in the Western world, we have 1 judge for 1 lakh population. Yet, the judges have been able to work over time. I remember, Justice Suraj Govindra sitting till 7 o'clock. While the judge, the lawyers grumble, he's still smilingly sitting there from 2:30, without even getting up for a cup of coffee or even to go to the loo. That kind of a thing judges we have. But then this digitization, these tools will definitely help them. Would AI be able to help them? Answer is yes. Because today you have AI tools which can synthesize, which can give a synopsis of the factual matrix. There are tools which can help you in looking up the case laws. Imagine when I came to the bar, we would look at a 50-year digest. From 1902 to 1950, there used to be a quinquennial 50-year digest. So we'll pour through them, page after page. Today, you just click a button and it will, give you a whole lot of case law, right from 18th century till now. What helps you? These are the technological advancement which ought to be integrated. That's being done. But probably more is required to be done. And that is where people, the pioneers like Justice Suraj Govindra are there, who have, gone out of their way to sit beyond the court hours to ensure that this digitization comes into the court system. Years back, 2006, I remember there was a lecture that I had to give. We had Justice G.N. Sabai, one of our eminent judges. In his memorial, there was a lecture. In those years, imagine this was some 20 years back or 19 years back. I quoted Chief Justice Andrew Lee of Hong Kong, which in a speech he made in Lawyership Conference of 2006, he said, lawyers today cannot survive without keeping pace with the technological development. Please imagine, 2006 he said this. Lawyers today cannot, that's in 2006, cannot survive without keeping pace with the technological developments. There's no choice in the matter. Competence in information technology and its associated management skills have become a necessity and will now remain one of the core competencies required of all lawyers. He also stressed that a lawyer should not be a mere legal technician, but should be a legal professional with a concern for public good. 2006, when I spoke, I also said this. There's a huge gap between technology and the tools used in the legal profession and the outside world. Outside world was marching ahead. The technology in the courtroom was very, very archaic. And I said, many of us remain so traditional in our efforts that we center around archaic tools, typewriters. Even 2006, I still had typewriter, though of course I had computers and all that. Still, I retained one typewriter. These are things which have changed. Today, you don't see a typewriter in any office, any court, any lawyer's office. If you find one typewriter, it will be preserved as an archaic thing, to be preserved, in a museum. That's the situation. A time will come. In fact, when I first purchased my computer, it had some 100 or 250 kilobytes. Today, you are running into TBs and whatnot. So, it is in this era that we are, that technology must be evolved into the court system so as to ensure efficiency of judicial delivery system. As was rightly pointed out by Justice Suraj Govindraj, today, the common man has still faith out of the three limbs of the state. He says, I have better faith in the judiciary than the other two systems or other two limbs of the state. So that to ensure that, that trust, that faith is continued and improved, technological advancement, technological tools, if they are evolved into the court system, we will be able to dispose of the matters at a faster rate. Yes, matrimonial cases are required to be disposed of in 6 months. We now know it takes at least about 3-4 years minimum. Now all that, why? Because, when you start examining a witness, it has to be physically, typed out. If you have tools which you already have, which digitally records, you can have a video conference and then, you can have digitization of, whatever they speak, computers automatically type it out. Your own iPads and iPhones today have it in your hand. Therefore, that can be utilized in the courts. All that is being done. And if it is done, definitely the faster pace of dispensation of justice is possible. Richard Susskind was a professor in Oxford, and he was also the IT advisor to the Chief Justice of England and Wales. He has written a number of books, and he says, in the next decade, he said this about 7-8 years back, and this has not become reality, but it's a course of time it will. He said, there are new jobs for the lawyers. What he said was, 1, the legal designer thinker. He says the person who thinks about how we design systems and processes that are going to meet the needs and wants of legal end users, a legal design thinker. a job for the lawyer. Second, he says legal process analyst, person who can look at a complex piece of legal work, identify and settle on the most efficient and effective way of breaking down and conducting the legal work. A legal process analyst. These are all things which are available in the IT sector. All that has to be done is bring it into this code system. Third, legal no-coder. A lawyer without coding experience who can think in a structured and logical way and develop systems with their software and tools merged to support this. A legal no-coder. Fourth, a legal knowledge engineer, person who looks at a complex area of law, interprets the law, converts into a form of a decision tree or a flow chart to make it more accessible for users. According to Susskind, he says a legal knowledge engineer has a potential to design a system that will be used by millions of people around the globe. 5. Legal project manager, person who brings the discipline of project management into every dispute. And Susskind says he believes that the legal project manager will be the future of the legal professional. Specialist, people know how to identify, harness, and make the most available data. Legal risk manager, person who puts the fence at the top of the cliff rather than an ambulance at the bottom. That is exactly what the client wants. Now, all this is what will come in a course of time. Of course, he said this 10 years back, 7 years back. We have not yet achieved this here, but in a course of time, these are bound to be reality. And those persons will definitely help in better dispensation of justice. Now, AI. One of the things that, always, as was rightly pointed out, is the risk that we run when we depend wholly and solely on the digital era and the information available on the net. Last year, about 9 months back, I had to speak about AI. So in the court system, I went into the net, tried to find out whether anywhere in the world, this is about 10 years back, not even 6 months back. Anywhere in the world, they are using AI to give judgments. And the net said, yes, Estonia has done this. And they have a court system where AI dispenses judgments, delivers judgments. I had a little doubt. What I did was I went to the website of Estonia itself, and they said, we don't do it. Why I am mentioning this is, there is always a risk, as was rightly pointed out. These are tools, but ultimately human intervention is absolutely essential. And human intervention is needed for supervising the technological tools. Use of tools will be efficient, it will make you more efficient. But ultimately, it is the humanness, the kindness, the sympathy, the empathy, which the machine learning can't have. It's only the human beings, the judges who have human feelings, who can give a better judgment and delivery system, a judgment delivery system. It is in this era that all these tools have to be used, and they are meant to ensure better dispensation of justice system, to ensure efficiency, to ensure that we are in a better position to give succor to the people. And I think I have spoken more than enough, because I see there are still at least about 4 or 5 speakers. And thank you very much for this. It's been a wonderful experience listening to Justice Suraj Govindaraj, and I'm sure we'll have more insight into this from the other illustrious panel that we have. Thank you very much.
Thank you so much, sir, for your thought-provoking address. Now, I request our next distinguished speakers, before we start with Sir Shri B.C. Trivengadam, I request Ms. Sarah Benjamin to introduce her.
It is my honor to introduce our keynote speaker, Shri B.C. Thiruvengadam, Senior Advocate at the High Court of Karnataka, International Arbitrator and Mediator, and the Honorary Director of the Bangalore International Mediation, Arbitration and Conciliation Center. With more than 4 decades of distinguished practice, Thiruvengadam Sir has established himself as a pioneer in corporate law, intellectual property law, constitutional matters, and alternative dispute resolution. He is the founder of Thiru and Thiru, a legal 500 law firm, and has been instrumental in several landmark innovations, including structuring India's first venture capital fund, creating the first cross border stock option plan, and setting up the first American private equity fund in India. As the co-founder of the Bangalore International Mediation, Arbitration and Conciliation Center, ranked among the top 20 ADR centers in the world, he has been a driving force in institutionalizing mediation and arbitration in India. He has trained more than 4,000 lawyers, judges, and professionals in India and abroad, and has served as a master trainer for the Supreme Court's Mediation and Conciliation Project Committee. An internationally recognized thought leader, he has presented papers at numerous global platforms. Most recently, in June 2023, he addressed the United Nations in Geneva on UN SDGs, AI, and the future of legal professions, and signed the Joint Declaration on the ethical use of AI in the legal profession. He has also lectured at institutions such as the New York Law School, Chicago Kent College of Law, and several leading Indian law schools and professional bodies. Sir is also authored the acclaimed book Making Minds Meet Conflict to Consensus, and has been recognized as a legal icon by Asia's Laws IBLJ, featured in LexisNexis. 100 legal luminaries in India, and honored by David A. Clark School of Law, Washington, D.C. We are truly privileged to have with us a legal luminary, an institutional builder, and a visionary in dispute resolution. Please join me in extending a very warm welcome to B.C. Thiruvengadam Sir, our keynote speaker for the day. Thank you.
Thank you for your kind words. Good afternoon, Honorable Justice, Mr. Suraj Govindraj, Judge High Court of Karnataka, respected Senior Advocate Mr. Uday Hulla, Mr. P.P. Hegde, and Mr. Raghuraman, Honorable Professor Dr. M.S. Benjamin, Dean Faculty of Law, Mysore University, Ms. M.K. Savita, Registrar of Mysore University, research scholars, and who are organizing this event, Mr. Syed Kudrat Hashmi and Mr. Srinivas N.K., respected teachers of law, fellow lawyers, scholars, students, staff of Mysore University, and dear friends. It's a privilege to address this seminar on smart courts, pioneering digital pathway to justice in India. The topic involves intersection of law, technology, and justice delivery. It's the integration of all the three factors. And this topic is definitely timely and transformative. I thank the organizers for inviting me to speak today. I'm grateful to Justice Suraj Govindraj for highlighting many issues which are absolutely relevant. I'm not going to stick to my written speech, but what is relevant is the topic on digital divide. But more than digital divide, friends, the task that is taken up by the Indian judiciary is humongous. 11.5 crores cases per year is something unparalleled. But at the same time, a survey conducted by Lexquisite would reveal only 9% of the disputants have access to courts. There are various factors for it. Some may consider it's not worth fighting a case, good money chasing bad money. Family compulsions, like people do not want to enter into a litigation when their elders are there. Women do not want to litigate when there is a stigma of, even though when she's beaten and bruised by the husband, does not want to go for a divorce because it's a stigma. Various factors. But it is strange, 91% of the disputes do not come to the courts. His Lordship Justice SBC nice to say, the concern is not docket explosion, it is docket exclusion. There are various stakeholders. It is not judges and lawyers and courts. There are various stakeholders in justice dispensation. Apart from the judiciary, the lawyers, the litigants are the most important people. The litigants comprise of a common man, rich, poor, irrespective of where they are, business entities, various other institutions, profit or non-profit, and most important, the largest litigant in this country were government and government agencies. Apart from that, we have prosecution, police, and law enforcement authorities, and various other organizations like Legal Service Authority, correctional institutions, legislatures, law commissions, academias, technology providers, mediators, arbitrators, and conciliators, and also the United Nations. I'm going to briefly touch about it later. So when there are multiple stakeholders involved, in a country like India, when there are about more than 11 crores cases are filed, it is not surprising that there are delay or complaints of inefficiency. This happens because when there's a disjunct in the link between the various stakeholders, we need to have a harmonizing system. One hopeful solution is the smart court. Smart court is not like a phone. The word smart does not mean something pretty, attractive, nice, or beautiful. The word smart is an acronym for S for specific, M for measurable, A for achievable, R for relevant, and T for time bound. So acronym of this, abbreviation of these is SMART. And smart court is not merely a computerized courtrooms. A smart court brings in and offers digital case management, e-filing and e-payments, video conferencing and virtual hearings, real-time transcripts of proceedings, predictable scheduling, AI-assisted legal research and analytics, data dashboards like National Judicial Data Grid, and in some jurisdiction, like as it was mentioned in China, AI-assisted decision-making. When I stepped into this profession in 1983, I had the privilege of working a little bit with an organization called Indian Space Research Organization, and happened to work very closely with some of the top scientists like P. Sudarshan, Professor S. Chandrasekhar, and Dr. T.N. Seshan, who was later on become the Chief Commissioner of Income Tax, Chief Election Commissioner. And also I worked as a junior of a former Commissioner of Income Tax who had set up a computer school in St. Joseph Indian High School. I was attracted. I was also advising CDOT at the point of time. I was attracted to the computers as such. I bought a second-hand PC, but did not know what to do with this. It did not have a hard drive. There was to be 2 slots, and one you have to load what is called the boot drive. The boot drive will have the program, and another floppy disk you have to insert. So whatever you have to work on the program will be copied in the floppy disk and you take away. But the challenge was no printers were available. So in order to get an interface with an electronic typewriter, the cable, which costs now about 5 to 10 rupees, I had to buy it for 4,500 rupees. It was challenging. But the scientists whom I worked with, which led me to become a patent agent too, were visionaries. They said, not just the legal, any other profession, even legal profession is bound to change, and you're going to see changes that happens very rapidly. Heraclitus, the Greek philosopher, said, the one thing which is certain in life, one thing that is constant in life is change. And that is true. So what is the purpose of having small courts? As rightly pointed by Justice Govindraj, as well as Learned Senior Counsel, Mr. Vadevalla. It is not to replace judges or lawyers, but to empower them with tools to reduce delays, cut costs, and expand access to justice. While I was being introduced, it was mentioned that I was a signatory to the Geneva Declaration in June 2023. The declaration with respect was, as I represented India, and there are 135 countries representatives. It was discussed, debated, and resolved that AI, as well as any technology that is going to be used by lawyers or anyone in justice dispensation, should be aware of the ethical use of it. It cannot be misused or abused. As Justice Govindraj said that the case in New York, a citation was given which absolutely was totally false, fabricated, imaginative. And the lawyer who used it believed that AI, whatever the case that was generated by AI is true, which is not so. The responsibility is on every lawyer who takes the help of any AI tool, maybe ChatGPT, or so there are so many today, to ensure the veracity and correctness of it. And one of the declaration also says that if a lawyer has used AI for any segment of its work, whatever proportion it may be, it is the duty of the lawyer to disclose to the client that it is not his own intellect, but to an extent, whatever extent he has used AI. This is very, very important. The declaration was supposed to be circulated to various countries and adopted by various bar associations, which I dutifully did. I'm not sure whether it has happened or not. But the advantages of smart courts cannot be ignored. First of all, as I said, efficiency. The smart court's digital case management speeds up hearings, reduces paperwork. This means faster disposal and fewer adjournments. Kerala has set the example by establishing pilot smart courts in the High Court as well as in the magistrate courts. And it's been proved to be very, very successful. Accessibility. Virtual hearings allow litigants, even from remote villages, to attend without long travel. I need to mention an incident that occurred during the pandemic. There was a huge dispute concerning the Bangalore Metro BMRCL and a church called the All Saints Church. There are issues with respect to land acquisition as well as environmental issues of uprooting more than 115 trees. This dispute was referred by an European bank to me and to Dr. Vinay Kumar, who's former conservator of forests, to be mediator, facilitator. The church was represented by 400 odd people, and the environmental group, about 5 or 6 of them, and officials of BMRCL. It took about 8 sittings from morning till evening, entirely virtual online. And the result was extremely successful. And it is in the news that as against more than 42,000 square meters of land, only 250 square meters of land will be acquired that goes beneath, the station is going to be built beneath the earth, and only 11 trees are getting uprooted. This is the magic of technology and virtual hearing. Everyone seems to be satisfied. There are cases, as a practitioner of arbitration and mediation across the border, several cases are done without me stepping out of Bangalore. As I sit as an arbitrator and with co-arbitrators in other countries and parties in different locations. Everything is done with proper case management system. The next most important thing is transparency. Orders and judgments are published online in real time in smart courts. This can eliminate few cases where there can be tampering of records, and this will also ensure public trust in the judicial system. Cost cutting is something which would bound to happen. It cut down costs of travel, cut down unnecessary paper costs, it cut down delay, which overall reduces the litigation cost, which will benefit a common man. During COVID as such, everyone knew that all the courts, most of the courts function online, including subordinate courts as pointed out by my senior counsel, Mr. Udayola. And not only that, the Bangalore Mediation Center, now it's called the Karnataka Mediation Center, handled more than 1,000 mediations online. The mediator sitting from the house and the parties respectively to different locations. This is the magic of technology, which can be fruitfully used by the judiciary. It is not enough to have mere smart courts. We need to have smart court complexes too. That is where the e-Seva Kendras could be of great help. It can provide Wi-Fi services, access to the parties as well as the lawyers, paperless research and e-libraries, and various other facilities which can be thought of. One of the most important aspects which the Supreme Court as well as our High Court is looking at is possibility of instant translation of judgments into local languages. After all, the judiciary is meant for the people. And what is the purpose of having a language which is not going to be understood? No doubt, the language, constitution as assured, the language of the High Court and Supreme Court has to be in English. But it as if it can be understood, if it can be easily translated. And this can happen in smart courts too. Smart courts are not without challenges. Digital divide, as we all been talking about. More than 50% of our population are still offline. One person told me, look at even an auto rickshaw wala is having a smartphone and is able to watch movies streaming through Netflix or so on. So it is not that easy. It is not merely having a smartphone in hand would enable someone to have an access to court proceedings. As I'll be saying that they require a little bit of digital training also in respect to how they approach the courts. And especially in the rural areas, many lawyers found it extremely difficult to participate. Even now I get complained that they don't have an access to internet, or even the internet bandwidth is very, very poor. Cybersecurity is a major concern and it will be going to be a challenge. And it is essential, sensitive data of the courts, even a judgment that is going to be released or in-camera proceedings have to be protected and from data theft or manipulation. A country like India, to implement smart courts across the length and breadth of this country, of the nation, is going to be a challenge. It involves humongous amount of investment, capital investment in servers, secure platforms, upgrade of software, plus maintenance and manpower to continuous maintenance. And 7,500 crores that is deployed in the third phase is not enough. We can't try to imitate what China does. But in our own way, we can make slow steps, but slow and steady steps. Change is often resisted. Some judges, as well as lawyers, feel very comfortable with traditional system of court proceedings. But resistance slows down technology, adaptation of technology. So change, we need to understand, is something which should be accepted for the overall good of the nation. When we talk about digital divide, there's also exclusion. As I pointed out, 91% of the disputants do not come within, knock the doors of the courts or lawyers. Recently, I gave a talk at the Supreme Court Bar Association when I tried to recommend mediation should be used, and lawyers should automatically, every advocates association should set up a mediation center or kiosk and support pre-litigation mediation without burdening the court. I was challenged by the then bar president. He said, no, you're going to take away the work away from the lawyers. One simple question I asked, hypothetically, if I owe a sum of about 5,000 or 10,000 to that said lawyer, and I don't pay it, will he file a case? He said no. But if the same 5,000 or 10,000 dispute is referred to a young grad person who passed out of law school, who was trained in mediation, is it possible, will you give a try and pay him a fee of 500 or 1,000 rupees for the 5,000? He said yes. So we need to understand that there is an exclusion. But if smart courts come in a way and try to help these small parties, small disputes, imagine there may be a maid in her house who is abused by her husband. Can she go and spend her time in a family court, leaving the work? She may be a daily wager, or give up the work and fight in the litigation in the court. We don't seem to understand the problem of a common man. Justice should be accessible, and that's where smart courts can play a very, very important role. The Honorable Supreme Court even contemplated evening courts. without disturbing the entire process. Smart courts can facilitate evening courts at convenience of parties and lawyers. Much have been said very elaborately and very effectively about global perspectives about smart courts by Justice Suraj Govindraj. I'm not going to say much about other countries because he's already covered it. I will simply dwell upon the thoughts of two organizations. One is the European Union and second, the United Nations. The European Union is very, very skeptical about use of artificial intelligence. They are very conscious about, the use of ethics and access and safeguards and rule of law. Its new AI Act calls AI as a high-risk application, which requires strict oversight, transparency, and most important, human accountability, which the learned speakers, Mr. Udayawala as well as Justice Govindraj said. Without human accountability, without human intervention, let us not even think of having any smart code. The European Union also has invested huge sums of money in e-justice platforms. This to help cross-border litigation, and they have used what is called the e-codex, which allows electronic communication of courts between one country and another country, recognition of e-signatures, document transfers across member states. So it balances rule of law and safeguards and ensure technology does not erode and undermine justice. The United Nations, through the United Nations Commission on International Trade Law, UNCITRAL, has not done anything directly on smart courts. However, two or three acts of it gains a lot of importance and be relevant to smart courts. In 2024, UNCITRAL adopted the model law on automated contracting aimed at overcoming legal obstacles to automation, while ensuring technology neutrality and legal certainty. The same principle would be applicable as and when smart courts are implemented around the world. UNCITRAL's Working Group 2 is currently drafting rules on technology-related dispute resolution, trying to bring a balance between innovation and the due process of law. Further, the Singapore Convention on Mediation, Settlement of Mediation, encourages online dispute resolution. It recognizes e-signatures. All the contract can be signed electronically. It is a forward step, and the entire mediation can happen remotely, either in a virtual fashion or even a hybrid mode. Virtual hearings, according to UNCITRAL, there is a word of caution too. UNCITRAL says there may be a greater risk of external influence over witness testimony, underscoring the need for protocols to preserve fairness. Just imagine if a witness is going to be examined remotely, what is the guarantee that the witness is not going to be tutored? And the judge or the arbitrator may not even know who is behind tutoring the witness. So that is the reason this word of caution comes in. And steps are being taken as to how to prevent these sort of issues which may mar fair witness testimony. In short, the UN perspective is very, very clear. It says, though it encourages technology and says it must enhance justice, at the same time, it says technology should not compromise justice, which vision, in my opinion, is fully aligned with India's smart court journey. I also need to mention something very, very interesting that is happening around the world. Smart contracts and dispute resolution. I have a friend, perhaps His Lordship Justice Suresh Govindraj may know, who is a first batch from National Law School. He's spending a lot of time in research. His name is Mr. Joseph Puckett. Spending a lot of time and research in smart contracts and building it with ODR, online dispute resolution mechanism. The smart contracts are self-executing agreements stored in blockchain platforms, where an outcome or outcomes are automatically triggered once certain conditions are met. It has built-in ODR clauses. For example, if I import a product, say a laptop from Singapore, online, and it is delivered in a damaged condition, the smart contract triggers off the claim immediately, and it refers to the arbitrator. The arbitrator pulls the entire evidence from the blockchain and delivers his award within a short span of time. This involves manual intervention. Unlike what is happening in China, it's a similar smart contracts, but with AI judges. The concern, as far as China is concerned, there are many. One is, most apart from the political statements, which I don't want to talk about, where is the part of equity that is going to be brought in? Where is the humanness? Justice Govindraj exhibited the qualities of a humane judge few minutes ago when he mentioned about, in an MVC case, a driver's leg is amputated. If you, as he pointed out, if you are going to have AI to decide what should be the damages and what is the degree of disability, it may work out to be in accordance with law or justice. But where is the equity element? We belong, we apart from civil law, we predominantly follow common law. In a common law regime, equity does play a very, very critical role. And this is where human element is absolutely necessary. As far as India is concerned, Mr. Hulla mentioned in 2003 about video conferencing. Interestingly, in 2003, late Justice Dr. G.C. Baruka of a Karnataka High Court pioneered video conferencing facility at the Parapna Agrahara prison outside Bangalore. Every day, several hundreds of under trial prisoners were brought from Parapnagarara, which was outside Bangalore city, to the city civil court, which should take at least about 1 to 2 hours of commuting time, and they had to wait and go back. Justice Baruka realized that it's nothing but a waste of time and introduced video conferencing under trial hearings, which is one of the foremost trendsetter. The launch of e-court mission mode project in 2005 has already been discussed. There was phase 1, which involved computerization of 14,000 plus district courts and subordinate courts. And in phase 2, implementation of e-filing, e-payments, and video conferencing were introduced. I must share, in 2018, our Supreme Court, in a landmark judgment of Swapnil Tripathi, versus the Supreme Court of India, enabled live streaming of court proceedings. This was followed by a judgment by Justice Oak in Dilraj Rohit Sukeria versus Union of India in our Karnataka High Court, which I had the privilege to argue, enabled live streaming, which commenced in 2021 in Karnataka High Court. In 2023, phase 3 of the digital mission started, and it is meant for digitalization of entire records, court records, universal e-filing, AI support, and establishing e-Seva Kendra, which is underway. I don't want to talk much about the Kerala initiative, which is already spoken by Justice Suraj Govindraj. It's been a trend center and in establishing e-courts. Another institution that has played a very important role about smart courts and ODR policy is Niti Aayog. Niti Aayog in the year 2021 came out with a policy and report which promotes and encourages online dispute resolution for high volume disputes, small disputes like low value disputes, consumer disputes, check dishonoring cases. I can proudly say that Bangalore International Mediation Arbitration Conciliation Center, which I represent in an honorary capacity, pioneered in establishing virtual arbitration and mediation since 2013, which is acknowledged by Niti Aayog in its report, as well as the Government of India Ministry of Law. Now the road ahead, where are we heading to? What we need to do? The first and foremost task is to bridge the divide. How do we bridge the divide? Is to enable internet penetration into rural areas, increase the bandwidth, and provide affordable devices, or also digital kiosks. This will ensure that litigants poor or in remote villages, small towns, are not excluded from the judicial system. Cybersecurity, as already pointed out by Justice Govindraj, is very, very important to prevent hacking and data thefts. Above all, training is a must. As rightly pointed out, training should be imparted by law schools. And it's not only law schools, by various engineering colleges and institutions and skills centers at low cost or no cost for lawyers and the public. Bar Association can take a lead, respective Bar Association can take a lead in providing these trainings. And law needs to be updated. No doubt, there's a recognition for digital signatures and electronic evidences. Further steps should be taken as to how these should be implemented. ODR awards should be given effect to. We should validate smart contracts too. All this will go a long way to ensure that people retain faith in the system. And finally, again, I repeat that AI can assist research in scheduling or analysis, but the final decision must rest with a human judge. Justice must remain compassionate, ethical, and humane. In conclusion, technology is not a magic wand. It is a tool. A smart court without a smart judge, smart lawyers, or litigant is like a smartphone without network. It may look sleek and attractive, but it's useless. The true measure of smart courts will not be servers or applications, but whether they bring us closer, us in the sense, all the stakeholders closer to the constitutional promise of justice for all. As someone privileged to sign the UN Declaration, I feel as a personal duty to ensure India not only adopts smart courts, but becomes a global leader in ethical, inclusive, people-centric justice. Let us together build courts that are not only smart, but also just, inclusive, and humane. Thank you very much. Jai Karnataka. Jai Hind.
Thank you so much, sir, for your enlightening address. Now, I shall have the privilege to invite Shri Mr. P.P. Hegde, Senior Advocate, High Court of Karnataka. Before we proceed with sir, I request Ms. Sarah Benjamin to introduce sir. Sarah, over to you.
It is my honor to introduce our distinguished speaker, Shri Padma Prasad Hegde, a designated senior advocate practicing in Bengaluru, Mangalore, and New Delhi. He is also serving as the president of the Karnataka State Bar Council. Sir has earned a reputation for his deep knowledge of law and commitment to justice. His firm, P.P. Hegde and Associates, undertakes significant work in areas such as family law, criminal law, property law, land acquisition, debt recovery, and administrative law. He was admitted to the bar in 1993 with the Karnataka Bar Council and over the years has demonstrated leadership not just in courtrooms but also in legal institutional work. As president of the Karnataka State Bar Council, he has led several initiatives, including actions to ensure legal practitioners adhere to professional standards and to address issues of fake or unqualified practitioners. In recognition of his advocacy skills, Sir was recently promoted to the rank of senior to his professional eminence. His opinions are sought in complex legal matters, both at the state and national levels. He has appeared in numerous cases and is respected for his clarity, ethical standards, and balanced approach. We are privileged to have with us a speaker who embodies both the practice and the governance of law. Someone who bridges advocacy, institutional responsibility, and public service. Please join me in extending a warm and respectful welcome to P.P. Hegde, sir, our distinguished speaker for the day. Thank you.
Thank you, Sarah. Good evening, my dear friends. My dear friend, Dr. Benjamin from the University of Mysore, Srinivas from the department, and all the persons in charge, staff and members of the Department of Law in Mysore, Honorable Justice Suraj Govindaraj, who has guided us with this great experience, and he has been pioneering this digital path in Karnataka and also in our country. And he hardly uses the hard papers, only the soft copies in the courts. And many times we advocates, we feel we are lagging behind. And we are happy that our real guru in the profession, senior advocate Sri Uday Holla, who has been ideal to all of us. And in fact, I should say, he's not only a teacher for all of us, but if I see all of us, I feel he's the youngest of all of us, because he started taking the not only the computers, as Sri Justice Govindaraj just now said, in his office, started with the computerization of the office, which was unheard of. Probably some youngsters would have even, others would have thought that this is not for the future. This is something, a new idea. Not only that, he was probably the first person who takes the laptop with him always, and all the records will be with him. And he is the first person probably who has digitalized all the case laws, all the important decisions, and readily available. In fact, even many of the honorable judges would ask for Sri Uday Holla about the propositions of law, because not only his memory is great, but also everything is also fed into the computer. So he has practically and properly digitalized, and we are grateful that he has given his innovative thoughts, which are for the future. And also the distinguished speakers of this now the evening, all of them, I am grateful to each one of you for being present here and giving an opportunity. My dear friends, we have heard from the judiciary, we have heard from the leaders of the bar. As a practitioner, I would only say the digitalization has long back started. And this has, in fact, made the life of an advocate, from the perspective of an advocate, much easier. I would remember earlier, an practicing advocate who is in the litigation would hardly take any leave, even for a family function or even when there is a condolence. But now, because of the digitalization, even in times of distress and where he has to travel outside, he can appear in all the courts. This, even in my college days, I could not have dreamt that this is going to come. I remember the days, my dear friends, when during COVID times, when the Honorable High Court of Karnataka, through the then Chief Justice Woka, opened the courts digitally to everybody. At that time, as Sri Uday Holla sir remembered it just now, I remember some of the judges would say from the bench, virtually sitting, please open. They would say, please open and please join. Judges themselves calling us and saying, open and you start speaking. And please join. This itself is like, I was thinking that the justice has really come to the doorsteps now. Judges are calling us to start our submissions virtually. And many times, at that time, the judgments were being immediately uploaded, orders were being sent, and many times these soft copies were immediately sent to the jail authorities for release of the prisoners who were granted bail. This itself was a great transformation. And virtual courts have now become the reality. To some extent, and to a larger extent, it's indispensable. As Justice Suraj Govindaraj just now said, as far as the advocates are concerned, we are now able to appear in multiple courts at a time. We appear in the Harvard bench and also in Bangalore court, sitting in our office, and we are able to appear in many number of courts. And in Karnataka, the utilization of the digital courts is the most, and the advocates have welcomed it. There is absolutely no protest or opposition by the advocates. The learning process is on. And we have the best of the judges. Many of the judges are completely paperless. Even the present Honorable Chief Justice is paperless in Kotal number 1. So that inspires all of us. And as far as the classrooms are concerned for the future, we should, many students I have seen, the law interns, they start with the laptops, everything is soft. So the digital library is with the students. So I feel a brighter future. Evidence of the witness is also being taken. And I was saying earlier, a decade ago, or 2 or 3 decades ago, when a hardened criminal is being produced before the courts, he had to be accompanied with so much of police force. Now that is stopped. In all the trial courts, the accused are being produced virtually wherever physical presence is not required. There were earlier many encounters of the dead criminals while being produced before the court. This also stopped. It has eased the criminal justice system and also helped the law enforcement authorities to a large extent. Recently, the Delhi Lieutenant Governor issued a notification pursuant to the amendment in the BNSS that the police station should be designated as the seat of recording evidence. This was, of course, opposed by the lawyers. This was basically on the ground that is the police station is the seat of recording evidence virtually. Then a fairness will be lost because witnesses may be fearing to speak the truth because it is the police station. Apart from that, there was no objection, I feel. Later on, however, that notification has now been withdrawn. Now the governments the authorities are required to notify the places of recording evidence as per the new amended provisions in the BNSS. And now I feel the concerned governments will notify some third party or neutral places for recording evidence. Nobody would have any objection if it is something outside the court premises or something which is pertaining to the education institutions or other places. Now, recording of evidences through virtual mode also helps in speedy disposal, and also the witnesses can adjust their life, manage their life accordingly. Otherwise, many times we have seen, especially in the criminal courts, witnesses come and wait for hours together, and at the end of the day, cases are being adjourned. So there is the main complaint, the practical front I have seen is witness asks at what time my evidence will reach. Many times we do not have answer for this. This has resulted in the witness has become hostile. The very reason is that he has to waste time in the courts for long and there is no certainty, would itself be an incentive to not give the proper evidence. So therefore, to stop this, if a proper time is set and also along with that, virtual appearance is also permitted, this would enable the witnesses to speak freely and truth will come out more efficiently. So digitalization will definitely help. As far as the pathway for the future is concerned, I feel the future is bright. Only thing is we should be aware and that there will maybe some misuse. What I feel now is one thing is we speak of digital courts. We see a rampant cybercrime pertaining to digital arrest and siphoning of the funds in the guise of digital arrest, etc. People should be more aware of this, are required to be educated about this. And I feel where these number of cases or cyber cases are more and more, number of criminal cases pertaining to cyber case is more than the regular cases. So this, to some extent, we should be careful on this front. But digital world is in fact the future, and the courts have been digitalized. And we have the earlier, each of the bar associations would come and request the bar council for funds for setting up the libraries. Now, nobody is asking for the library. They are asking for e-libraries. In fact, I feel our mobile itself is the e-library. Only thing is advocates must be able to use it. I feel to some extent, the advocates are not properly utilizing it because we are more into other social forums like Facebook and WhatsApp, etc. But at the same time, I feel once the advocates start using it properly, it will also help the court system in rendering the justice effectively. And earlier the system was that an advocate's office should be filled with the books and books. Now I feel many times I also question myself, when did I open the book last time? Because every time we open the digital world, we don't rely or go to the hard books. So the future is digital. Future is everything is will be e. That's why e courts and the same thing. I feel the future is e lawyers. And e-students have already coming up. So we have to keep pace with the development of technology. One thing I feel, my distinguished speakers here and honorable friends, that technology is running fast, is much, much faster than the changes in the law. The law may be lagging behind. The lawyers may also be lagging behind much. And my only note on this point is, at this point, the technology has helped the police machinery for e-FIR is also being digitally, it's being lodged. And in the High Court of Karnataka, I'm very happy that e-payments are allowed. It's helping even the advocates and the clerks to make the payments. Of course, lawyers, we are also used to e-payments now. Virtually payments are being received. So we are asking the clients or writing the letters to the clients, please come to the office. Many times the purpose would be for settling the fees. So that's also is not there now. Many times the Google Pay helps all of us. So the life has become very easier with the technology. In fact, I started, the life of the advocate has become more easier. I asked a question to myself many times. We are at the very office space. And in our office, we sit and argue the cases. And as Honorable Shri Udayavalaji just now said, when Justice Suraj Govindra sits at 6 till 7 without any coffee, without any break. And many of the honorable judges are, because of the workload, they have to sit till 6 p.m., 7 p.m., etc. Sometimes I ask a question. Now, advocates, we are used to this form of continuous appearances from the office. I have not seen any honorable judge sitting at his home and doing the virtual hearings. They may have to come probably that the honorable judges also utilize it. We are ready to make our submissions because from the office of the honorable judge or from the court doesn't make any difference. In fact, if the cases are so much beyond the hours, beyond 4:30 or 5:30, etc., the honorable judges are staying themselves continuously. I humbly feel the best way is the honorable judges shift themselves either to their office or to the chambers or to their home, and they do the hearings, so that we are also concerned with the good health of the honorable judges. This will help in more efficient dispensation of justice. And one more, my thought, we have started the live telecast of the Karnataka High Court, of all the High Courts. Live telecast has been there and virtually available. Now we are percolating from the Supreme Court down to the Honorable High Courts, and down we have to now go to the district courts. So the courts really become open. Everything becomes transparent. Faith of the people with the courts has become more now. It's because people know what's happening in the courts. On a experiment basis, I suggest, because we have Honorable Justice Suraj Govindaraj, we utilize this opportunity, who is in fact has been pioneering everything new things, innovations here. So we may have to start on experimental basis, at least in some of the districts, that the proceedings of the district courts, at least some of the district courts, become live, so that people are able to see and participate. Of course, in the initial days, everything becomes interesting. Now I feel there is no such rush to log in by the people. Of course, some of the bytes will be used in the YouTube. This will be there for some time. the interest will also stop later, but it becomes easier for people to log in and watch. And that's how this process educates the people. And we educate, sit in the courts and we are educated. Many times we now sit in the our chambers, we watch the proceedings of the Supreme Court and other honorable judges of the High Court sitting at the office, and the education continues. So in the digitalization process, our education, our training is a continuous process. This should now be available even for the taluk and district courts being opened up with their publishing the live telecast. With these words, my conclusion is digitalization cannot be stopped. Digitalization and digital world will move fast. Virtual courts and virtual appearances will be an instrument in our country for fast and speedy delivery of justice. And the moment we are able to achieve more than the other countries, we achieve the best in the e-court system in our country, that will help our country to become the superpower in the world. That's all our dreams, and to give justice and render justice to everybody. In Karnataka, there has been a lot of achievement, the greatest achievement, and we're happy for convening this conference virtually. Thank you, everybody.
Just to answer two things that were raised by Mr. P.P. Hegde and Mr. Thiruvengdam. Insofar as AI is concerned, we are experimenting with Jana.ai as regards use of the AI for the purpose of bookmarking and administrative activities. And insofar as the district courts are concerned, that Mr. Hegde raised, 410 courts will be digital courts very shortly. The equipment is already installed. vConsole will be used. There's a distinction of live streaming and YouTube recording. If live streaming, all the courts in High Court of Karnataka are live streamed because vConsole is available. Anybody can log in as a public and watch the proceedings. YouTube, only few courts are being, the proceedings which are being uploaded because of the security, etc. The 410 digital courts which will be there as vConsole, again, even the general public and the media could log in and watch the proceedings. Even students could log into the proceedings. It could be for the university and the colleges to identify where good cases are going on, which could be educative, as you rightly pointed out, where the students and lecturers could also log in and watch the court proceedings, either in the High Court or the trial court. It could be a cross-examination. It would be live. So they could watch the cross-examination sitting in class. It could be a final argument in a sessions matter, which could be watched sitting in classroom. Those are things where there'll have to be a little proactivism on the colleges, not the university, on the colleges, to identify which are the matters which are going on and to ascertain and make available resources for the purpose of logging on and watching those proceedings. These 410 courts are digital. vConsole will be installed there. They'll be live streamed very shortly. Many of them are already live streamed. The rest will also be.
Yeah, we're thankful, very thankful.
Thank you so much,
Thank you.
Your Lordship, for insightful reflections, and thank you, Sir P.P. Hegde. Now, I shall request Shri Mr. V. Raghuraman, Senior Advocate, High Court of Karnataka, to address the participants. Before we proceed with Sir, I may request Ms. Sarah Benjamin to introduce Sir, and we shall proceed.
It is my privilege to introduce our distinguished speaker, Shri V. Raghuraman, a designated senior advocate with an exceptional academic and professional background. Raghuraman sir is a rare combination of legal and financial expertise. Being a chartered accountant, cost accountant, and company secretary, having passed all three professional courses with distinction. His academic journey is marked by excellence. He stood first rank in BCom from Bangalore University, secured All India 38th rank in CA Inter and 24th rank in CA Final, as well as second rank in ICWA Inter and 25th rank in ICWA Final. With over 35 years of professional experience, Sir has built a stellar career, first as a chartered accountant and later as an advocate. He regularly appears before the Supreme Court of India, various high courts and tribunals, specializing in taxation and foreign exchange matters where his expertise is widely respected. Beyond his practice, he is a prolific academic contributor, having addressed more than 500 seminars and symposiums across India, sharing his insights with students, professionals, and practitioners. He has also authored significant works, including landmark international VAT judgments published by Walters Clover and GST and Indirect Tax Demystified, published by commercial publishers. Today, we are honored to welcome a professional of outstanding merit whose mastery of law, finance, and taxation has enriched both practice and scholarship. Please join me in extending a very warm welcome to our distinguished speaker, V. Raghuraman sir. Thank you.
Thank you, Saraji. I hope I'm audible.
Yes, sir, you are audible.
Yes. Thank you, sir. Gives me great pleasure to be amongst the legal luminaries here. Justice Suraj Govindraj needs no introduction. Whether you have e-court or you have just a manual court, number of disposals will remain with him. He will be in top speed, disposing maximum number of matters in a day. What can be said of Mr. Uday Kolla, who is the leader of our bar for so many decades? We have also had the benefit of listening to Mr. Thiruvengadam, and his rich experience comes out, and very practical approach to digital course by Mr. Hegde. After having listened to all this, my job is much, much more easier because I have to only concentrate and tell the people here what are the areas where, as practitioners, as litigants, we should be looking into. The first and foremost thing that strikes me is when I started my practice as chartered accountant was with a typewriter, as Mr. Odla rightly said. And typing, retyping, all that has become completely a thing of, if I tell my sons today that you used to type and retype, they laugh and tell, what a stupid guy you are. Then we had to tell him, no, there was no computers then. Because I remember when I was doing my articleship, the first computers came and we were taught DOS and Lotus. The word was not there. DOS and Lotus were taught, and then the word program and other things came much later than that. So one of the areas which now which we have to concentrate on in smart courts is what I feel is technological literacy, which is substantially improved in our country in the last 10, 15 years. The literacy that is required is seen with the UPI spreading across even to the flower vendors and the fruit vendors who are able to use their cell phone to get their payments. But then the literacy required in smart courts is something much, much more different. Your traditional methods of arguing cases do undergo a change because you are sitting rather than standing. Those who are used to standing will know that the body language is very, very important in conveying. But when you are sitting in the courts today, and you're also sitting, your body language is hardly understood. So to that extent, what happens is you'll have to shift your body language when you're technologically appearing e-courts, so that your points are put across effectively. Second, you should be able to concentrate. See, the process in e-courts is to make the entire process quick. The traditional method of arguing for hours and hours together has to go. In fact, in many of the courts in the Western countries, much emphasis is given on written submissions and very little on the oral part of it. And understandably so, because once you argue the case before the courts, the judge will have to remember, and it's very difficult for him to remember everything. So your written synopsis, which is given to him, which cannot exceed more than 3. Today, the Supreme Court puts this, even the high courts here put this limit. It should be 3 to 5 pages. So your literacy should be so high that you're able to condense your entire arguments into 3 pages and put it across, put it in a PDF file and give it to the judge. The judge is not deciding only your case, he is deciding hundreds of cases. Now that comes to the next tool, which is very important, the digital research tools that are available today. One of the greatest advantages of AI and its disadvantage is this, that it is able to condense across its search hundreds and hundreds of cases and put it into a capsule, which is useful not only for the lawyer, it is extremely useful for the judge. And what is that disadvantage? The disadvantage is this. If you're able to give the correct questions, you'll get the correct answers. If your questions are incomplete or inaccurate, the answers that you will get from AI can be misleading. This is a very, very important aspect that has to be taken into consideration, not only by those who are legal, who do legal research, assistants who do the case law searches, but even the judges who actually go into the AI and try to get out all the information that is available on a particular subject. Where we find AI like Gemini or even ChatGPT really not, able to narrow in, is because your questions that you put are not accurate. Now, your digital research tools that you should use should be in such a way that your questioning is not only accurate, the research tools itself should be enough to do a search that will get you the results. Now, if you look at Gemini or ChatGPT as far as lawyers and judges are concerned, I would say that it is woefully lagging. The reason I'm sorry to be a tamper in these proceedings, but I have done the searches myself as a senior to see how this actually works. And I find that, if you, for example, you give a famous case, any case that has been argued in India, just put it out into the ChatGPT and Gemini AI, and you will find interesting results coming out. They are not complete, 1. 2, it could be misleading. 3, the ChatGPT and AI could be speaking of something else also. So your questioning should be very accurate and your filtering should be very accurate. But the databases that are there today in, for example, the SEC database that is there with its Boolean search, which they have, it narrows down the search to such a fine print that you can find 10 of the leading cases in each of this. This kind of a search engine should be built into our high court systems, so that the judges will be able to get all the case laws on a particular subject. The reason I'm telling you is this. It's quite possible that the litigant lawyers who argue may assist the court to the best of their ability, but may not be update absolutely the latest case laws which appear. Maybe last week something has come. Maybe 2 weeks back something has come. And we may have missed it. Now, this is an area where I find that if your artificial intelligence can catch the data and put it there, it will be of immense help to the judges because they will not be reliant only on the arguments of the counsels on a particular subject matter at that point of time. When they go back and do their research, they will be in a position to actually update the counsels who have appeared on what has happened subsequent to that, and which will have an impact on the judgments that they are going to pass tomorrow. Obviously, when they reserve a judgment, they pass it after 10 days or 15 days or whatever it is. In that gap, you could have had some judgments coming. And it is that gap which can be filled very, very, very efficiently by the digital research tools that are available and which have to be updated on a real-time basis. That is a very important consideration that has to be taken into mind. Now, a very, very apt system should be one which integrates all the players, the litigants, the lawyers, and the judges. All of them. This is not a smart court is not just that I come by VC, appear and then go and it's all done. Or the judge listens to the litigants and then says, okay, yeah, back up. No. A smart court is a system where from the time I file my petition up to the time it is disposed of, it is one integrated system which operates. Everything has to enter into the court, the smart court, and exit through a judgment. That is the objective of having a smart court. Is that at any point of time, the litigant, the lawyer, and the judge should know what is the progress in this case. Litigant who probably is in a village in Karnataka should be able to go to his digital kiosk close by and then say he should know what is the status of his own case. It's very important that the litigant should know what is the status of my case, what is happening. And he should be able to see the orders, these interim orders that are passed, what is happening for it to his own eyes. At the same time, even for a judge, if he enters into the system, he should know the history of the case. It should just flow like that. And the submissions that have been made by the both the lawyers at any point of time should be available before the judge so that when he goes back to dictate his orders, if he's dictating his orders in his chamber, he should be in a position to look at that what is being filed, the data that is there, and to recover it real time. You just look at a typical case. See, for example, Justice Suraj Govindraj is now sitting in Dharwad. Now he has to carry his cases from Bangalore to Dharwad. He may have reserved 20 or 30 very important cases to be decided. He would have left for Bangalore to Dharwad virtually overnight. All those 20, 30 cases files will have to be shifted to Dharwad, and he sits and reads through them in his whenever he gets time. Now, rather than that, if you're able to retrieve the cases and the arguments in your system, it will be so much easy for him to just look at that and decide and pass orders. Now, we are looking at, when you look at smart courts, it is that system which enables each one of the stakeholders to actually work efficiently. This is all. Which, if you're more efficient in your job, the matter ends. The other, because I happen to be a chartered accountant, cost factors are always very important for us. What I mean by cost is, let me tell you, cost of litigation in India is not even 1/100th of the cost of litigations in the Western countries. That is the truth. So that from that consideration, there is no problem. But there is one which Justice Suraj Govindraj very beautifully highlighted. 10% of the cases. Those 10% of the cases which keep backlogs, that creates a Damocles sword on corporates and on individuals. There are so many cases today which you find going to the Supreme Court. By the time they reach the Supreme Court, 20-25 years, the cause title will read X deceased versus Y deceased. Both are dead. The legal representatives are fighting the case. Now, this is a Damocles sword hanging over the head of the people. If this sword can be removed through the usage of smart courts, we would have met what I think one of the things that always people blame India for is the delay in arguing cases, delay in decisions. They do not know one important factor. US Supreme Court will decide 12 cases in a year. Justice Surit Govindraj will have 150 cases per day. Please understand, there is substantial difference between those who lecture us and actually doing the work. Please put them in this situation where you have to do 150 cases a day. They will not be here for more than 2 hours, I'm telling you. I'm openly telling you this. Not even 2 hours they will spend here. They will run off. All these people who lecture. 150 cases a day is listed before in his cause list, and he sits till 6 and 7 o'clock. Inhuman. He goes back and he has to dictate for another 3 hours. How many people are seeing that? Not many are seeing it. He has to go back and dictate 3. He leaves at 10 o'clock in the night. Invariably. He's also a human being with a family. So I think, the smart court, I am not in favor of extending this to the houses of the judges, because please don't make their life more miserable than what we have already made it. Let them have some rest at their houses. Please don't extend it. But we did see it. Let me tell you. In the Delta wave that happened, the Uttarakhand, I had to appear before the Uttarakhand High Court, and both the judges were doing the the streaming from their houses. The commitment, I'm saying. You saw the Karnataka High Court do that. The commitment, you see, the division benches, they were sitting across from their house chambers. So there is absolutely no issues with the smart courts. It will be very efficient, but the stakeholders also should have a commitment to that. 2 issues which I think we should take care of. One is, I had said that all people should enter into the system in the High Court so that we'll be able to file and see the case progress. Perfectly all right from a statement point of view. But when it comes to privacy and data protection, what steps are necessary for that to happen is one of the issues which it plagues every country. I'll give you a simple example. When I file a writ petition in an income tax case, it's quite possible that I have to produce the balance sheet of a company, the income tax returns of a company. Now, this company does not want its data to be floating around. It can't be in the hands of the entire world. A professional hacker who hacks into the system can take out this data. So privacy and data protection, we have to invest heavily in that, and that's a huge amount of cost that the country will have to incur if they want the entire system to be, through the smart system. There's one concern which has come about in US, the Compass algorithm. This algorithm, you see the bias that the AI generates itself. African American citizens, a bias in the algorithm that they are high risk. So the method of dealing with their cases undergoes change if they are a high risk category in smart court systems. Now, this is something which we have to be very guarded against, because the moment we build an algorithm which is not open to the stakeholders' eyes, but which comes before them as a bias inbuilt into the system. This bias, which is inbuilt into the system, can have extremely deleterious effect on the way cases are conducted and way cases are selected for conduct. We can't have high risk, low risk algorithms built into systems and making people, classifying people even without hearing them or knowing who it is. This bias has unfortunately entered into the United States in some of the, especially in the, it appears that this bias was detected during the bail judgments procedures which happened. As was rightly pointed out, AI, smart court systems, efficiency is one thing, but I can tell you, just like Justice Suraj, it doesn't make a difference. Manual court, electronic court, disposals are very high. They don't care. He doesn't care. But it will make his process efficient. But the balance has to be struck between efficiency and fairness. If we follow the Chinese system of deciding cases completely without even, where the AI becomes the judge, then, you have a concern. You have a concern there. A judge cannot be replaced. Your brain, the judge's brain cannot be replaced. The lawyer's brain cannot be replaced. I would leave you with this thought that what we require is efficiency in processes. We talk of, interference on the decision-making process rather than the decision itself. AI, all your algorithms, all your softwares, everything is written as a tool to justice delivery system. It doesn't replace any of these stakeholders. Stakeholders remain. The stakeholders are human beings, living beings, properties, where emotions are attached. So therefore, any system which is built in can improve your process, but cannot substitute your decision making. With this, I would thank the Mysore University and its organizers for inviting me to share a few thoughts on smart court system. I deeply thankful to all the organizers. Thank you very much.
Stop the live. Thank you, sir, for your insightful address.